It's my pleasure to have you all here. My name is Laura Lazaro Cabrera. I am a Council and Program Director for Equity and Data at the Center for Democracy and Technology Europe. We're a fundamental rights organization based in Brussels, trying to uphold fundamental rights in European tech policy. So today, I think, especially after a couple of days of CPDP, we're all quite aware that we're at a time of regulatory upheaval. We have recently closed the door on a European Commission mandate, which saw significant additions to the European rulebook, and yet at the same time, we're hearing growing conversations that seek to significantly revisit some of those hard-fought regulatory milestones, not least the GDPR. With that, we think it's a good time to reflect on how far we've come since GDPR was first adopted, particularly drawing from lessons on its enforcement here with the company of my esteemed speakers. We know that data protection authorities have been a vital actor in ensuring redress for fundamental rights harms through the frame of data protection. But now that we're looking at the AI Act implementation, we also know that actors such as market surveillance authorities under product safety legislation will also come to play a significant role. There are ongoing talks about if and the extent to which data protection authorities will be appointed as market surveillance authorities for the purposes of the AI Act, with many countries contemplating at least some level of oversight being delegated to data protection authorities as market surveillance authorities. So wearing two hats at once, if it were. Now, one important realization is that we are dealing with two incredibly different regulatory frameworks. When it comes to data protection authorities, the primary frame of reference is the General Data Protection Regulation. And when it comes to market surveillance authorities, these are creatures that have been long regulated by product safety legislation. So it is high time that we look at how these two frameworks interact and the extent to which their particularities may strengthen some mandates or weaken some others. Without further ado, I'd like to introduce you to our fantastic panel here today. First, to my left, we've got Rocco Saverino, doctoral researcher at Vrije University Brussels, a member of the Law, Science, Tech, and Society Research Group. Then Maria Magierska, senior lecturer at the Maastricht University European Center on Privacy and Cybersecurity, also this year's CPDP GDPR quiz winner. To her left is Thomas Zerdik, head of the Enforcement and Supervision Unit at the European Data Protection Supervisor, and last but not least, Ichazo Dominguez de Olazábal, Policy Advisor at European Digital Rights, affectionately known as EDRI. So I'll first kick it off to Maria to open up the discussion. Maria, could you tell us what are some of the procedural guarantees afforded by the GDPR in case of data protection harms, and how does the AI Act compare?
Yeah, thanks so much, Laura. It's a pleasure to be here. Thanks so much, everyone, for coming. I'm looking forward to this discussion. And, well, let me focus first in this answer. It's a very broad answer that you ask, because you ask about the frameworks under the GDPR versus the AI Act and both the public and private enforcement. So maybe I focused first on the public enforcement, and then we can move to the private one. So just the complaint mechanism under GDPR versus the AI Act, because I think this is also the core of different thinking of how the AI Act is constructed versus how the GDPR, this rights-based regulation, was intended to be. And so let me start with the GDPR. As you know, we have the Article 77, the right to lodge a complaint with the Data Protection Authority. And from its principle, and this is, I think, something that we are still grappling with when we speak about potentially deficiencies of enforcement of the GDPR, is that these procedural guarantees there are very highly individualized. And so the right to lodge a complaint is tied to a data subject who has who considers that the data processing infringes regulations, but the data subject can file a complaint that relates to specific processing activity that violated his or her specific data subject rights or other principles of the GDPR. So it's very specifically tied to certain individual somewhere there that files a complaint. Of course, there's Article 80, but the it also maybe offers rather the possibility of the data subject to be represented by the NGO, and the potential of the NGO acting without any mandate. It's very limited, it's only applicable in certain member states. Now under Collective Redress Directive, it's slightly different, it might change, but we are going to talk about it later. So in general, this design of GDPR, right, the complaint right, is very individualized, and which creates problem when I think of how the data fight world works, where this puts a lot of burden on individual, because we need to be aware about the violation at all. So we have to already, the individual needs to be aware of what's happening there with their data. So we need to be informed, sufficiently informed, and so that's create a big power imbalance at the very beginning. And then, well, it goes to the complaint, the Data Protection Authority. This also opens yet another discussion, because depending on the member states, the status of the complainant is very different. We may be acting as a party to the procedure. We may act I'm not saying informant, because the Court of Justice clearly said it's not the case. But let's say we have less procedural rights depending on the member states where we are based. So. And then we have the Court of Justice, who is really on the side of with the data subject here, because the court had repeatedly stated that the complaint under the GDPR is not a petition, is subject to full judicial redress, and the Data Protection Authority is obliged to handle the complaint with due diligence and reply to the complaint, and it's tied with this obligation to keep the complainant informed. Now, how it is in practice, it's not perfect. It's far from perfect, and I know that DPAs have different understanding of what this informing the complainant scope, what it means in practice, and I know there are people in the room who are on both sides of this dynamic, but still the GDPR offers it. And it's not really the case under the AI Act. So this brings me, we are now at the AI Act, Article 85, right to lodge the complaint. So first of all, this right wasn't there during the proposal negotiation. It was added thanks to also the efforts of many of you in this room. In the end, we have the right to lodge a complaint, but even in the recital, it still states that EU law already provides effective remedies to natural and legal persons. So it's already there, this thinking that we have GDPR, we have judicial redress, so we don't really need the right to complain, yet another one under AI Act. And it's very interesting because it's completely at odds with the mechanics that are there and the other new rights, new laws, right, such as DSA and DMA and so on, which usually offer this available remedies. They tend to broaden it. And instead, AI Act, it's more narrowing this perspective, and also introduces the right to lodge a complaint understood as the information that is submitted to the authority and should serve as a direction of whether there was a violation of the AI Act, rather than being tied specifically to certain violation, like response to certain data, here not the data subject, but like user harm. So this is opportunity and difficulty at the same time, and I think there is more difficulties here, particularly because how this Article 85 has been written. If you compare it even in the AI Act, 85 with 89, you'll see that under 89, the right to lodge a complaint by downstream providers, there are already, there's this whole catalog of the complaint, what it needs to fill out. It's not the case with Article 85. The complaint is very vague, the notion of it is very vague of who can file the complaint, basically almost everyone against everyone under and with the Market Surveillance Authority. But it's not specified what you do in the cross-border cases. It's not specified whether Market Surveillance Authority has the obligation to respond to, it's not tied with any deadlines, it's not tied with this right to inform the complainant of what's going on with the case. So it's completely devoid of these redress protections that are there in the GDPR, as much as not perfect they are in practice, but still this protection is not there in the AI Act at all. And one thing that is also against this trend, and I'm going to talk about it, is this lack of collective redress. That it's not there mentioned specifically. That against what is there even in the Data Act, DGA has it, the right to collectively file a complaint. So it's also against this trend. And finally, maybe to close it, although we can have a special session only on about this right to complaint. The lack of any cooperation mechanism in cross-border cases for me is also very troubling, and the fact that there is no possibility to lodge a complaint with the AI office against the general purpose AI system, unless so the scope is quite limited here. It's only Article 89.2 and only specific actors that can be there. So it's, I understand where is it coming from. I understand this thinking of the market surveillance authorities and the possibility of using different judicial redress or administrative redress to protect the rights of individuals, but still, like, this mechanism is, as it stands in the AI Act, is rather than information for the market surveillance authorities rather than anything else. And we will see how it will work out in practice, of course. And it will be many, contrary to the DPA's last point, DPAs in many countries, they're already established, they know what they are doing, and they have this tradition of complaint handling. And here we will end up with many market surveillance authorities, and Rocco will talk about it, with many different hats coming from different regulatory traditions, with different ideas on how to even understand this complaint handling, the procedure. So I expect a lot of mess and a lot of fun for us to observe it. So thanks.
Thank you so much, Maria, for that overview. And I guess it's a little bit of a preview as to what we may be discussing next CPDP. But I'd like to turn to Ichazo now, maybe picking up on some of the points already made by Maria. To what extent have the procedural guarantees in the GDPR lived up to their promise? And I wonder if you want to add the examples of how civil society organizations have been able to capitalize on those.
It's not always civil society organizations, but I think we have some heroes there. So yeah, I'm thanks so much for being here, and thanks so much for reminding from the very beginning that the GDPR is a rights-based regulation and not a risk-based obligation. Even though we hear constantly that this is changing even from institutions and from many actors, and I think this is a push. This is something that we have to push back against, and I think this panel and everything that we're going to shed light on, I think is going to help us, trying to understand why GDPR allows people to see their to see their rights protected, whereas in the case of the AI Act, maybe that's not so self-evident, and maybe some people have to go to the GDPR instead of using the AI Act in order to fight against the damages and the harms caused by AI systems, be it high-risk systems or not. Just an overview of the articles that Maria already mentioned, just in order to understand. So we have first the complaints to supervisory authorities. And again, these are individuals, so we've been told that, and also I think one of the wonderful things about the GDPR is the principle of proximity. You can go to your DPA, you don't have to know anything about GDPR, even though some DPAs complain, oh, we see citizens that just complain about everything that they don't understand. I'm like, okay, this is how GDPR was created, and I think this is good. This is people, regaining control not just of the data, but also of their possibility to actually hold somebody accountable, even if they don't know the law. So the thing is, and again, we've been hearing that, but again, many DPAs lack sufficient resources. I don't think it's about resources, and we can speak about that afterwards. When it comes to market surveillance authorities, we might have the same thing. That leads to lengthy delays. So when it comes to redress and when it comes to remedies, how long should a data subject, how long should anybody wait until their right is satisfied or their complaint finds a decision? Some complaints remain unresolved for years. I don't know, maybe we can do a quick poll afterwards about the length, the median length of the cases you've been seeing. And at the end of the day, this undermines trust and creates a de facto denial of remedy. And I think this is something that we want to avoid for the other rules of, again, not criticizing GDPR. Maybe this is not a problem with GDPR, with others. But also there's good examples, and this is something that I also wanted to emphasize. I'm thinking of course of Schrems too. We wouldn't have the US and the European Union having to break their heads in order to figure out how to circumvent the system if we wouldn't have a complaint that had gone to the CGU in order to create a geopolitical scandal, and in order to actually being very aware of how the right was at the center of the system, even if it was against a country such a powerful as the Commission, as the United States, and an actor like the Commission that never accepts that they have to reassess their adequacy decisions. Then we have judicial remedies against controller or processors, and this is a very tricky one. And actually now with cross-border, with GDPR procedural, when it comes to cross-border cases, we are realizing how tricky this is and how much resistance there is from member states to accept that the DPA might be wrong, just as, again, any authority, any public entity might be wrong. So this provision is completely underused. Correct me if I'm wrong. And again, sometimes it's because the peoples rely on the DPAs, and when they don't find the solutions when it comes to the DPAs, they will say, okay, let's go to the court. Unless then they know that they have the expertise, and what else do they need? They need the money, and this is a strong problem, right? If you don't have just those resources, it's going to be impossible for you to go to the court, but also the legal expertise. Then you have Article 80. That was the big hope that all of us had when it comes to GDPR, and we've seen that delivering, right? We've seen so many wonderful cases from NOIB, from La Quadrature du Net, things that have actually not just provided remedy to individuals, but actually changed the systems, changed or forced companies to sometimes change their practices, sometimes just slightly. That's the problem, and maybe we can discuss that afterwards. But it's even that it's not working as it should, especially when it comes to cross-border procedures. And is it about resources? It isn't about resources. It's about the lack of political willingness from some actors. Again, there's very inspiring examples. I had also here an example that I really like. It was a decision by the Italian DPA against Globo in order to protect workers' rights. And this is one of my favorite decisions because it can also show how GDPR is not just about the fundamental right to data protection, but it's about the other many human rights that are attached to that. And then there's also the big elephant in the room, which is the liability and the damages, right? Something that anybody from the US understands it perfectly, but when it comes to the EU, it's like, okay, how are we going to handle that? What are we going to do? The material damages, of course, but also the non-material damages, right? And this is something that I look forward to developing. We saw that with the Bindel case, and that was already exciting. But you also asked me about the gaps, right? So I'm not going to shy away to point to some of the responsibles, the Irish DPC delays and weak enforcement. I'm not going to enter into why, but we've seen that for years. And when it comes to remedies and when it comes to redress, it's deeply disappointing that it's not just how long and how torturous the process are, but also how this DPA uses amicable settlements in order, in their hundreds, in order not to handle that complaint and in order not to get the data subject even the right to signal that something is wrong, and we get back to this idea of, is it a mere petition or not? No, you have to investigate. You don't have to go to the company, trust 100% what the company says, and then withdraw the case. I was saying a huge gap for me will be the difficulty enforcing Article 82, and how, at the end of the day, remedies are really important in order to obtain redress. It's never always about a decision, no matter how satisfying the decision might be. And at the end of the day, and this is something that we always say at EDRI, when it comes to GDPR, when it comes to data-driven harms, because we prefer this, there's a non-material damages. There's so many harms that are attached to the way that data is used, and I think, there's a responsibility to try to tackle that as soon as possible. It's not just, they speak about anxiety. It's not just about anxiety, whereas, I also understand the part about anxiety or being afraid, but it's, again, there's people whose data is being used in order to feed recommender systems that afterwards are going to harm themselves or their children. Just an example. We also see failure to act on biometric surveillance and when GDPR applies. So I think this, even though we've seen some great cases against Clearview, I think this is interesting. We see cases in gaps in collective redress, as Maria already mentioned. There's many countries that do not want to acknowledge that this exists. And when it comes to the RAD, and I'm going to keep it calling RAD for a long time because I love the name. There's many opportunities, but also there's lots of things that still have to be decided. There's things about forum shopping, jurisdiction, even the applicable law, and also the costs. Again, something that I'm going to insist again, and I'm sorry, on this GDPR procedural law that is being negotiated. The thing is that if you don't allow the citizens to obtain satisfaction, the citizens, not the people in the EU, because all of them have the right to obtain satisfaction when they go to the DPA, and they have to confront this horrendous, for now, one-stop shop mechanism, and they know that they're not going to get anything because there's cases that have been holding on for 5-6 years. You're forcing them to go to the courts, and not all of them have the money, not all of them have the patience, and even though for me it's a source of hope as a civil society organization, I think it's completely unfair because, again, we're speaking about different kinds of enforcement and the court is trickier. But again, a source of hope, but also a source of frustration on some guards. And yeah, I also wrote down things like lack of access to procedural documents. So the thing, procedural transparency, access to redress for marginalized groups. I think there has been cases, strategic litigation cases that have tried to shed light on the situation, on the GDPR violations against marginalized and vulnerable communities, but these are still very few, and when it comes to AI, it's the vulnerable communities that are the most impacted, so I think this is important to take into account. Yes, and proportionality of enforcement, and so I wrote, it's just 1 minute, but I wrote down something which is remedies work, but mostly, so you need to have already something, and you need to have a well-resourced civil society actor or complainant, a proactive DPA, and a politically willing DPA, and legal clarity and public pressure. Maybe there's some lessons to learn from the part of the public pressure as well. Sorry, it took me a little bit long, sorry.
It was a very robust overview of the tools at our disposal under GDPR, and it's a helpful point to bounce off Rocco. I'd like to ask you, Rocco, now that we've had some description of how the DPAs have enforced the GDPR and the obstacles that have come their way, I wonder if you could speak more to the difference between market surveillance authorities and data protection authorities, and if you see any opportunities and/or challenges there.
Well, thank you, Laura. Thank you for having me today. I will say that this conference, this CPDP this year is very enforcement focused, so it's quite interesting to me, and also talking about this with these panelists, I think it's an honor to me. I would like to start with something that you probably already heard, even from my colleagues, even in other panels. Data protection authorities are tasked with safeguarding fundamental rights, especially the right to data protection, while the market surveillance authorities are more to ensure technical compliance with the EU product legislation, focusing on risk elimination and market conformity. But so we can say that in some way that the DPAs are right-based regulators. Market surveillance authorities are only product compliance enforcers. Is this true? Of course, it's a provocation because the answer is yes and no, because of the hybrid nature of the AI Act, and also the complex regulatory system that is coming up day after day, I will say, because we are going to appoint these market surveillance authorities by the 2 of August, but we don't have a clear idea. Even the member states are not so clear about which authorities will be appointed or designated using the already existing authorities. But we can see also that there is a very strict connection with the product safety regulation. By simply reading the AI Act, the definitions, we can see this very strict connection with product safety regulation, because the market surveillance authorities under Article 3 are defined as national authority carrying out the activities and taking the measure under the regulation 2019-1020. So in this sense, I would say that there is more connection with product safety regulation than data protection, even though we know that for using AI system, we need data. So we cannot consider one without the other one. And also because of this, we have two lawful bases in the AI Act, Article 16 TFUE and Article 114 TFUE. One, of course, related to the fundamental rights protection, but the data protection, and the other one related to market compliance. So I think this is a kind of friction, or the more complex point to address when we're talking about authorities in the enforcement of the AI Act. And if we look at the data protection authorities, I already say that we have to look at Article 8 of the Charter, and this is this gives them a very unique characteristic, which is the independence by primary law, by the treaties directly, by the Charter. So it's something completely different that we have to take into consideration, because when we are talking about the market surveillance authorities, of course, it's mentioned the opportunity, possibility to act independently, but how independence is considered in this case, because it's an independence different than the one that we have for data protection authorities. And this is mentioned in recital 156 and Article 70 of the AI Act. But still, if we look at each country, we will see that there is this confusion, heterogeneous approach. Why? Because we have a country where we have only one national authority competent for, acting as market surveillance authorities and coordinating, like AESA in Spain. And if you are going to look at the statute of AESA, you are going to see in Article 42 that they can receive money from private donations, so from private parties. So, of course, I already said that it's not the same level of independence of data protection authorities, but still, if you are going to oversight and to enforce a regulation, and then probably the subject that against which you are going to enforce the regulation can make some donations to you, how you can enforce without bias? Because in Article 70 and in recital 156, the word independently is accompanied by without bias. So I'm not sure how it will work in the end. This is my major concern, I will say. And yeah, I think I can.
Thanks so much, Rocco, for that overview. I wanted to turn now to Thomas, thinking more about what rules the GDPR sets for collaboration between data protection authorities and the role it reserves for the European Data Protection Board. And I wonder, what frameworks are there for collaboration between market surveillance authorities, if there are any, and how do these interact or could possibly interact with the Data Protection Board?
Laura, thanks for having me. And I think it's the understatement of the year when you say the GDPR has a framework for collaboration. Because actually, and there I tend to be more optimistic than Ichaso, the GDPR is designed to foster cooperation. So for me, in that respect, the glass is absolutely half full, if not even more. So if you think about it, you have an established traditional data protection supervisory authorities. The GDPR obliges all of these authorities in the 27 member states to work together and to ensure consistency. This is a specifically legal obligation. You have specific provisions in the GDPR on cooperation and consistency, very detailed rules actually, and ultimately you also have a deciding role by the EDPB in case, by the European Data Protection Board, in case these individual supervisory authorities can't agree on something. And to give you an example, the decision by the Irish Data Protection Commission to fine TikTok for unlawful data transfers to China, 350 million euros, is such an example where that decision went through the cooperation mechanism, and it works. So, again, a very clear legal cooperation framework framed as obligations. And yes, of course, we all know it doesn't work perfectly. There are hiccups, but these hiccups can be attributed to some individual interpretations, former interpretations of supervisory authorities, the interplay with national law, etc. So, but this is what we have. And now then we look at the AI Act, we look at what market surveillance authorities there are, and you find there's an even bigger number of market surveillance authority. You have separate market surveillance authorities according to the sectors in the member states. Yes, you have an obligation and a regulation for member states to ensure that they all cooperate, sort of, with each other, cooperation and coordination, but no details. At EU level, you have the AI board, which also has a specific provision even to say, unlike the GDPR, I forgot to mention, is the GDPR is closed. The GDPR doesn't have a sort of outlying article saying, hey, there are DPAs, but maybe there's the rest of the world as well, and you should talk to those as well. No, the GDPR doesn't do that. The AI Act does. The AI Act says in a very small provision, the AI board should also cooperate with other authorities. Yeah, but what does that mean? You see, what does it mean to cooperate? Does it mean there is a, what happens if there is no cooperation? Can you enforce that lack of cooperation? What does it mean if there is a dispute? Nothing. The AI Act has absolutely no dispute resolution mechanism if there were individual authorities, even market surveillance authorities, who diverge. That's very different from the GDPR. So, in earnest, de facto, today there is very little experience of data protection supervisory authorities talking to the existing market surveillance authorities or even the being established market surveillance authorities for the AI Act, vice versa, even less. So you asked me, what can we look at? Is there anything we can make, how to make this work? Basically, how to make the link, how to break the silos, because legally speaking, these are silos. There are two ways, very simple. You need to realize, and I think this is one of the biggest challenges already still for data protection supervisory authorities in member states, but even more so for market surveillance authorities. The moment you are a public authority and you are implementing Union law, you automatically become a European Union public authority. It is your duty to give effect to European Union law. And it is your duty, and that's expressed in one of the treaty provisions, Article 4.3, it is your duty to apply the principle of sincere cooperation. And it is your duty to cooperate, we call this with mutual respect, so everybody along their own competences, to assist other authorities to fulfill their obligations. And this is not just abstract and theoretically. We already had a case from the European Court of Justice in the Bundeskartellamt case, where that was exactly the question: can a competition authority talk and cooperate with a data protection authority? And the Court of Justice has said absolutely yes. You are both European Union public authorities. You have to apply Article 4.3 of the treaty. You need to assist each other. You need to talk to each other. And in case there is a divergency, the one who has the final say is the one who is in charge of the topic you're actually talking about. So That's one way, but of course it is still very broad and lots of leeway. The EDPB is currently working to see if there's anything we can put in place in practice, how to talk to other authorities. But of course, the best option would be, don't be surprised, if there was some sort of specific bridging legislation. Yeah, which basically, if you want some sort of European Union procedural regulation, which would very clearly say, you have authorities here, 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 and there. If there is a common topic, such as, you see, AI systems of high risk, talk to each other, first obligation, cooperate with each other, and how, and then also what happens in case there is a dispute, who has the final say. Because at the moment, that is not regulated. At the moment, you really have to go back to these fundamental principles, which exist, so you can make them work. But of course, every authority will tell you it's easier if you have already a set of rules which you just need to apply. So I wish us good luck.
Thank you for ending your intervention with that hopeful note, Thomas. Ichaso, I was going to ask you about the GDPR enforcement challenges and how these might live up or evolve in light of the AI Act implementation. But I saw you had some reactions to Thomas's intervention.
No, but I think there were good reactions. I think, yeah, I think, for example, I'm going to speak about GDPR procedure again. I know it seems super boring, but I think it's a very important regulation. And one of the provisions that civil society was also fighting for, but notably in line with what Thomas was saying, is that there's, of course, this principle of cooperation, and it has attached a number of criteria to it, but we don't see that happening as much as we see this chilling effect. For example, I'm thinking, in Article 15 DMA, companies have to issue reports about the use of profiling, right? And why is it in the DMA? There's a reason, but they have to share it with the EDPB, right? And you will say, oh, that's fantastic news. Then it goes to the EDPB, and the DPAs, if they have the political willingness, then they will say they will start an ex officio investigation, because wow, I'm sure there's very juicy things in there, but the DPAs don't do that, because most of the time they're afraid, they don't have the legal basis. And as Thomas was saying, we need authorities, and it's not just the DPAs. In the case of GDPR procedural, it was DPAs sharing information. But it's always much sure if you have the legal basis, and I think that we were told, or we were hoping, that this will be the mandate of enforcement, because we have so many new laws that it's just fair, and we keep seeing that enforcement is not being put at the center, right? And enforcement that, of course, has to be founded on cooperation, and very close cooperation between the different regulators. And for me, I love this. For example, I love the cooperation between competition and data protection authorities, because for me they go hand in hand. You saw the case in Luxembourg that was actually as a consequence of a complaint lodged by the La Quadrature du Net, and thanks to the ruling, that was even clearer. But it's true, and I completely agree with that. I don't think it's going to be included in GDPR procedural. But maybe you can exert some pressure in some ways to convince them to reopen that part. But I really think this is needed so much for more. I also forgot to say I'm all for cooperation, even between DPAs. But up until now, we know that this hasn't been as smooth as it should be, and there wouldn't be some cases before the court if that was the case. But something that you made me think about is that, when we think of remedies, we mentioned the usual suspects about, the articles, complaint-based remedies, right? But I also think that ex officio investigations can lead to remedies, and I'm thinking of the case of the Hamburg DPA against Meta AI training that is actually founded on one of the articles that has been also been underused in GDPR, which is Article 66, which is also one of my favorites, because when I was thinking of the profiling, I was thinking, oh, how are we going to force Irish to look into profiling? Maybe they have to be forced through Article 66. So yeah, again, ex officio investigations are something that for me are also that also have with them a glimpse of hope. For example, we have one of our members, Homo Digitalis, is a Greek member, and they went to the DPA insisting for months, saying that the Ministry of Interior had been abusing, had been violating clauses of GDPR when it comes to the treatment with migrants. And it was not a complaint per se, but it led to the ministry changing their practices because the DPA said so. So again,
I just had a little comment to what Thomas was saying, because Thomas just dropped a very big bomb, being the EU common procedural EU common procedure. So if you try to mention it in this parliament or in this commission, I'm sure there will be a good luck with trying to force it, and encourage it, as much as we all agree that we need this. Just to be clear. And here I was just thinking, if you, because we coming also. Following a bit the academic discussion that we have in the EU administrative law, I just know that you end up, when you start with the statement that public authority when enforcing EU law is European authority, European body, then you'll end up with this discussion, okay, so that's also Article 41 of the Charter applies, the good administration, but then you have the discussion about these different procedural rights, procedural autonomy discussion, so all of that, and it's very interesting. So there is actually a lot of dead ends in this discussion that needs to be covered. It's not just easy and straightforward, this mechanism. That's the first point, and the second, that when this bridging legislation is great reality when we are coming here from the European level, but when you talk to the authorities on the national level, the first thing they will tell you there is we are national authorities enforcing national law, and this European level is just addition. And I'm sure you know it from talking to them on the EDPB level. That's also raising awareness. I think it's a lot of that for this all European platforms to make it, and I think there is a long way to achieve it, especially now that we'll have all these authorities, not only the DPAs, who are, I think, the cooperation not perfect, it's still there. I think the awareness that it's European perspective, it's growing. With the MSAs, I think we will just have a long way to go. But sorry, this was a little comment on the side.
Thanks, Maria. Rocco, turning to you now, you've already hinted at some of the key features of market surveillance authorities and the open questions that remain. But I wonder if you could say more as to how market surveillance authorities are constituted under product safety legislation more generally, and what are we missing?
Well, I will start with something that probably something that is very useful for who is not very familiar with product safety regulation, like me, because I'm data protection biased. But still, I think it's very useful to look at the blue guide when you are going to, to talk about product safety regulation. You had to look at the blue guide of the EU Commission, which were updated very recently in 2022, and. These are non-binding but authoritative interpretations of tool that is very useful for us as academic, but also for business. And in this case, it's useful because it's useful to understand how it works with market surveillance authorities. There is a dedicated paragraph there, and also because if the AI Act recalled the blue guide. Why I recall the blue guide? Because in the blue guide there is something written very, very important, that a product that is, when you consider a product in the context of union harmonization legislation, this product should comply with all the union harmonization legislation. So imagine, for instance, that you have a medical device product incorporating an AI system presenting a risk, but this risk probably is not addressed by all the regulation because it's an AI system. So you have to, as provider, you have to integrate and comply, integrate the documentation and comply with all this legislation. So all of this for saying what? For saying that the AI Act will apply along with product safety regulation. And also, I have to remind you the constant recalls that the AI Act made for Regulation 2019-1020, because there are a lot. Even the definition of a AI system presenting a risk is the same definition of a product presenting a risk in Regulation 2019-1020. Because if you're going to look at it in the corresponding article in that regulation, you will see that it's the same definition. And this is also connected because the AI Act talk about AI system presenting a risk in the Article 79. And what is it said here is that the market surveillance authorities and the authorities protecting fundamental rights have to take all the measure, the corrective actions to bring the AI system to compliance, and in case this is not compliant, to withdraw the AI system from the market. So in this case, I have another question in my mind. The data protection authorities have this kind of power. Of course, they have the power to suspend the processing of personal data when it's not complying with the GDPR. But it's different from the role of the market surveillance authorities. And also, it's quite connected to a case, a fact that happened in Italy very recently, last week, I think. The Garante sent a letter to the internet service providers in Italy to inform about the situation of DeepSeek. Why? Because we had a situation, I mean, you are aware of this, we have an order in Italy that limited the processing of personal data, and because of this, they removed the application from the Play Store and the Apple Store, but still is available online. So you can access to the DeepSeek platform, and Garante tried to make something, you know? But the problem was that there is no jurisdiction there, and so Garante cannot do nothing. And also the internet service providers, in that case, they replied, I mean, this is something that you can find in the news, are proved, but the problem is that I couldn't see the letter that this president, the director of communication of Garante, sent to the internet service provider, because what they are saying is that actually there is no order, nothing, so they don't know what they have to do. And also, even though there was an order, there was a problem of lawful basis, so basically the hands of the Garante, in this case, are tied. Probably the market surveillance authorities can do something more. We don't know yet, because as we can see, there are more problems than solutions, and we are discussing about this. We love to discuss about problems. I'm sorry about that, but this is the situation. So it's something that we have to keep in mind and reflect about it, because I think it's something very important. And this multi-layer enforcement and authorities and complexities is just the surface of something very, very important.
Thank you, Rocco. And in the spirit of looking for positives, one key feature of the AI Act is that it empowers fundamental rights authorities to access documentation produced under the Act through market surveillance authorities. So I wanted to turn to Thomas to ask you about how you see this power manifest in practice, and whether we have any insights as to how data protection authorities could use this avenue as a fundamental rights authority appointed under the Act to try and access information and take action under their GDPR mandate.
Yeah, it's a great provision for DPAs and for any fundamental rights authorities, because it sends a clear signal, and this is really welcome. Okay, somebody has really thought about it, that there are other authorities other than market surveillance authorities, and has provided a specific legal basis to make them do their work. So that's great. But if you read it closely, it's actually, in a way, broader and more limited than you would think, because it's the power to request any documentation on high-risk AI systems in the first place. So not any AI system, it's high-risk AI systems from those who are using it, and then to inform the Market Surveillance Authority, actually. It doesn't say you have to go through the Market Surveillance Authority. That's an important point. So again, you do not have a very specific provision saying talk to each other from authority to authority. It just says you have the right to ask for the documentation, and then please let the others know. What is important is that it's also clearly not limited to your own jurisdiction, so you can ask cross-border. Exactly what we just heard. I can ask anyone anywhere in the EU to say, give me that information, give me that documentation. And then this is, of course, coupled with the obligations of market surveillance authorities later on in the other provisions to actually inform fundamental rights authorities, such as DPAs, if they think there are serious incidents coming from high-risk AI systems, or when they think that an AI system poses fundamental rights risks. How is that going to work? That's a very good question. I think before this is going to work, you would need to have three things in place. And the basic first thing is they need to know each other. Who are the market surveillance authorities in the first place? And that's still not clear yet. There's a very nice list on the website from the Commission, but that list isn't even complete. Not even all member states are there. And just the width and the range of authorities already from those member states is astounding. You already have 211 authorities who are fundamental rights authorities in member states. So you see, it's already a bigger number. So there will be a procedure, there needs to be a process of actually trying to identify who is who and who can ask what, and that still, there's no rule on how that should happen. You know also, and you've heard it from Rocco, the product safety market surveillance authorities are using their own IT system for information sharing, the information and communication system for market surveillance, the ICSMS. The European Data Protection Board, for example, uses another IT system, the Internal Market Information System. So these are different systems, and I would hope that if there were exchanges and requests under Article 77, somehow these systems would be made to speak to each other. But I haven't heard anything yet, if that is planned or is that in the pipeline. So it looks as if there's going to be an exchange of emails with attachments for the time being. And then, sorry to come back on this, if this is working, to give you an example, we in the EDPS, we are both Data Protection Supervisory Authority and Market Surveillance Authority under the AI Act for all European institutions, offices, bodies, and agencies. So how will that work? Well, we have two different units. One is the unit I'm leading, that's the Supervision and Enforcement Unit. We have the Data Protection Enforcers, and then we have the new colleagues who are the AI Act Market Surveillance Authority colleagues. And it's very clear that information within our own realms need to stay within our own realms in principle. So information the colleagues from the AI unit have is not automatically made available to us. Why should it be in the first place? Wouldn't be legal. So this is why this question of legal basis, like we have in 77, is so important. It's a pathway to say, you have a task, you need information, and this is how you can get it. Just sadly for the market surveillance authorities, you don't have that pathway neither. So the colleagues in the AI unit can't ask me, can you share information you might have gathered in another inspection and which might be relevant for their duties under the AI Act. It simply doesn't exist. So what we do internally, because we have the privilege of being one authority, we put rules of procedure. We will sort it out ourselves. We will write down, these are instances when I can ask the colleague, get me that information, and there will be instances where the other unit will be able to ask us for information. And this is seriously what is lacking. Again, we see this for the GDPR. We will have a GDPR procedural rules regulation because there are even instances between DPAs where these things are not clear. But it's not enough because you need standardized requests, you need templates, you need which language, how is it going to work? What about confidentiality? We even, between DPAs, we had confidentiality issues where I had a request and the DPA tells me, sorry, under my national law, I cannot share this information with you when I had issued a formal request under an investigation. So there's something which doesn't work. And then again, I come back to always to my pain point, if you want. Who decides in case of problems? Because Article 77 has a condition. It says you can ask for the documentation as Fundamental Rights Authority or DPA if it's necessary for effectively fulfilling your mandate within the limits of the jurisdiction. We're all lawyers, or many of us are lawyers. You need to check if these conditions are fulfilled, and maybe the Market Surveillance Authority or even the user of the high-risk AI system might come and say, you're asking me this, but this is not necessary for you to effectively fulfill that mandate. And what do I do then? Where do I go? Of course, I know I want that information. So this provision is great, but it's not quite as complete as you would like it to have. But anyway, I would say from the pure point of a data protection supervisory authority, if I have indications that there is a breach, there is a risk for the data protection rules being breached, of course I will make use all of my powers under, in our case, the EU DPR, or on national level, the GDPR, where I have unfettered powers. I can have right of access to any building, to any information, to any database, only subject to normal judicial protection, national rules on these things. So probably I'm going to use that way and not Article 77. But we'll see.
Thank you so much for that sobering insight, Thomas, and also the insight as to how a DPS is planning to manage these intersections and overlaps, which will hopefully be a blueprint for what's to come at EU level. Now, zooming out a little bit, Maria, I wanted to ask you, the situation being what it is, how can we look at private enforcement, a collective redress, or a product liability directive for a solution?
Yeah, thanks so much. So again, coming back to GDPR, and I think Istas was already mentioning Article 82. So we really thank the Court of Justice. From the last 7 years, they produced a lot of judgments relating to the interpretation of Article 82, particularly to the category of non-material damages. So there is a lot already to build from, because thanks to the Court of Justice, we have the clarity that there is no threshold to claim compensation for non-material data harms, and also that the data harms is simply, like the court traces very broadly, and it's usually even this feeling of a loss of control over data. That was the Bild case even recently, that it's just enough to claim for compensation. So this is a big opportunity, I think, already, that is also taken a bit, this reflected in the Product Liability Directive. I'm going to talk about it in a minute. But just staying for now in the realm of the GDPR. So as much as we have this developed case law now on the Article 82, and I think there is a big potential on how it will be, what's the future has for the private enforcement of data protection as opposed to the public one, together with the collective redress directive, or like representative actions directive. I'm still confused about the name because I think also it has been changing, So it's, just to be clear, it's representative actions directive, yes? Because we don't want to have the US collective actions. Exactly. So, so one big challenge that I see still is this, what I said at the very beginning of the session, that GDPR enforcement is highly individualistic, and it's really reflected in the court case law, the national court cases. So if you see how the Article 82 is applied in practice, in the cases related to non-material damages, especially in the context of these attempts of collective action. So I'm thinking particularly, I think there was WAMCA in the Netherlands that's already there and well-functioning mechanism. In the context of the GDPR, the courts are usually, for now, I think, they were mostly dismissing the cases or refusing to to grant remedies, saying that data harms is always individual, and like they are saying, so you have the group of people affected equally by the same data breach, the same violation. It doesn't even need to be a complicated GDPR systemic challenge. It can be just the pure data breach. The court will usually say every individual experiences this harm differently, and we can't grant you compensation based on this, like for the group as you stand, because each of you experiences differently. Now it's very interesting how it's different from this regular thinking of the group claims. Because even if you have, your flight is delayed, you all have the same compensation. No one, even though obviously we will have different repercussions for it for taking the part in the same flight. So, or like this, the holidays compensation or all stuff. So it's really a completely different reasoning, very individualistic, stemming even from this thinking about data protection and this highly individual right of command, of control of the data subject, which is simply outdated at this point. And I think we have the agreement about that is outdated because of the way the data works, the way we don't know about it. And we need to have this systemic approach and more collective one. So there is a way to it, and I think it's a big challenge now for NGOs actually to pull, and I'm sure it's there. It's like the law is there. It's just now, I think we are waiting for some big strategic litigation case that will overturn this thinking of individual approach towards data harms. And we see it, like there is a lot of inspiration we can take from I don't know, the Brazilian law, where they have it already, the societal harm category, for example. So there are really trends in the law across the world, which we can base on, we can actually learn. So it's not always Europe just teaching the world. Here is actually the reverse. I would encourage to take the inspiration from that. So now, how it is moving to the AI Act, how it's there. So AI Act, as I mentioned, the complaint mechanism does not mention this collective approach at all. Instead, we have, if you were there last year, perhaps you remember the sessions about enforcement where if someone asked about it, there was reply that, no, we will have AI liability directive, it will solve everything. So now we know we don't have AI liability directive. Instead, we have redacted product liability directive that had some elements of this now AI liability directive that has been revoked. So product liability directive builds, adds as a product definition of software. So technically, I think it's supposed to mean also AI system. And it adds to the right of compensation, first of all, a person, the collective action. So a person acting on behalf of one or more injured persons. So which I see here a potential to using it against the AI Act violation. And similarly, and it's very interesting for me, how the damage has been constructed, the non-material damage. Clearly, I think taking inspiration for this court's judgments under Article 82, what the non-material data harm is, but straightening it up. So here we have the category is a bit higher because it's medically recognized damage to psychological health. So there needs to be more proof of what this actually is. So it's like the fear, all this, like just the feeling of loss of control data is not enough. However, there is also a damage that is constructed as destruction or corruption of data that are not used for professional purposes. And it's any data, not only personal data. So I see there is a big potential on using this Article 5. And also other the way there was the proof of the burden of proof is designed, also allowing like actually considering the fact that the claimant may not really understand how the AI system works. So it's really here the burden of proof is maybe if the claimant faces excessive difficulties in understanding what's going on, like technically speaking, it's still like here the burden of proof lays more on the product product developer. So this directive, I think, may bring a lot. Like I see a lot of promises that may promise in this directive and potential. Obviously, we will see how the member states will end up implementing it. We will see also how the court will understand it. But just to be clear, I think if I want to have like one takeaway from what I was saying is this: we have all the instruments to allow for this collective understanding of data harms. It's there, but I'm waiting now for the courts to accept this as it is, because it's now our reality, and I just can't see if we proceed this way of this individualist thinking, it's simply flawed, and we end up with this discussion of under enforcement, and we complain. Like it's also bad for the authorities, because they end up with this like stream of complaints, and they are not able to process instead of having these instruments to make it more collectively. So yeah, thanks.
I know you want to make a remark, but I'm mindful of time, and we have just a few minutes for questions. So I'd like to open it up to the floor, and then we can come back. Okay. In order of appearance, actually, lady at the back, last row, and then at the front.
Thank you very much. Gloria González Fuster with VOB LSTS. I had two little questions. One from Maria just now. Aren't you being a bit unfair towards Article 80 of the GDPR? Article 80 gives the possibility for NGOs to actually lodge complaints, and there was a recent case, the Moose case, that originated in an Article 80 complaint, just the rights of people in general being litigated. Maybe it's not damages, but it works potentially quite nicely, so shouldn't we bring this back? And my second question was for Thomas. I think Maria already pushed back a little bit on this idea that there is a very clear EU law principle that says it's EU law, you're an EU authority, go and solve things. I think if people were aware of this, we would not have this proposal, procedural harmonization, which came from an EDPB wish list saying, oh, there is the GDPR, but we are really incapable of actually giving you effective remedies under the GDPR because of the national laws that are just blocking us. They said this, the EDPB said this, the Commission said, yes, maybe the GDPR is not strong enough. We have to fully harmonize what is already fully harmonized. So are we really have this principle clear in our minds? Thank you.
So yeah, on Article 80, yeah, I was, well, maybe it comes from my general disappointment with how the public enforcement of the GDPR like, in general. So I agree, I wasn't discussing this much because I see more potential in this collective redress directive, and we'll see also how these two will overlap. And I'm saying this, and I was focused more on that because Article 80 has it has not reached its full potential due to the fact how the member state implemented it. So the actions without a mandate are possible only in center member states, and they are possible in a couple of member states under certain conditions. And these actions are effective, absolutely, but I just don't think they reach this potential that they could have if there was more of it available. So that's why I was more focused on this potential of the collective redress directive, but I don't know, maybe Ichaso wants to add something like knowing
No, I think we've seen amazing cases just because we have amazing civil society organizations. I think I mentioned some of them. I think we have NOIV, we have La Quadrature Net, we have all the smallest organizations, and this is why we understand the full potential of Article 80. I think there's huge resistance in many member states and from many DPAs to actually accept even the legitimacy of Article 80, right? There's some DPAs questioning why are you making up the complainant? Do you really have an interest, or is this just because of your business model? Which again, it's not a business model; it's defending civil society, right? But yeah, I have to agree with Maria. I think. And I think this is a collective problem, right? How we understand GDPR as a highly individualized, and even if you see the court cases, and even if you see the DPA decisions, of course you can always interpret that as a collective measure. If the remedies are there in order to stop data flows, of course data flows are going to favor the whole of it. But when it comes to vulnerable communities, when it comes to collective data harms. For example, I was mentioning the case of workers, right? Or I mentioned, for example, all of these cases against credit rating companies. For example, NOIV has some of them that are mainly impacting a negative, low-wage workers. So things like that, I think that there's a high potential, and I'm very, very, very hopeful for Article 80, but also for Article 22, that has also something to do with the AI Act when the AI Act doesn't work. But I think it's just frustration because the GDPR was something promised very much, and we were really happy with that, and promised very much for all of us here, not just for the experts in law, and we are still not seeing the potential, and we've mentioned some of the problems, but yeah, I think thanks to those organizations that fight for that.
If I can come to Gloria's question on this. I'm an EU official since over 20 years, and it is surprising actually to see how much at national level there is still this willingness to understand that you cannot make a distinction between what happens at national level and the EU. We are so far intertwined with each other, it does not make sense. And also full disclosure, as one of the officials who has been drafting and working on the GDPR, if you ask me, the GDPR would not have needed another procedural regulation because the provisions are there, the obligations are clear. There is a case, you investigate. If it's from another country, you call your colleagues and you try to find a solution as soon as you can. But again, probably there was a serious underestimation of the potential to sabotage any effective enforcement in one particular member state from one particular authority, which hopefully has by now changed. But this is why we now have this additional rules to make it happen. And now again, full disclosure, private opinion, that only touches upon when it's already at the European level. It doesn't remove the issues at national level where member states can say, but my national procedural rules, they are providing for this and they're not allowing for that, and it's entirely different from in another member state. This is the problem. And therefore, anything which helps us to work better together, especially at the EU level, and to make it clear that any authority is an European authority is welcome, but I'm afraid we are still not there yet, and we need more procedural rules to go to the ground and say, if it's a data protection case, it doesn't matter where it is. This is going to be working within 3 months. If not, there is a delay, and then you have another 6 months, and you need to agree within that time, and that's it. I'd stop there.
Thank you. More questions? I remember we had one at the front. And we'll probably take 2 in one go. Can you raise your hand at the back?
Do you allow me to go for 2, or is it too much? Then I leave it up to maybe the panel to decide which one of the 2 to take. Okay, so I'm Mile Vidina from Equinet, so we're a network of national equality authorities, 47 public authorities in the EU member states and beyond, and the majority of our members are Article 77, along with data protection, consumer protection, data audiovisual authorities, competition authorities. In some states, they're up to 20 Article 77 authority. Now, my question is the following. Do you see a risk that the effectiveness of remedies under the AI Act might be undermined because of conflating Article 77 and the market surveillance authorities? Now, mind you, at least for equality bodies, but also data protection, other Article 77 authorities, we have independence under the law in some cases and constitutionally embedded. And then for market surveillance authority, you do not have nearly as robust safeguards, independence, which is why EDPS decided to separate the AI unit from Article 77, which my understanding, Thomas, would be your unit. So this is one question, the risk, and the second question is, and is more for Itsaso, is whether the GDPR could ameliorate or mitigate some of the shortcomings of the AI Act when it comes to biometric surveillance by law enforcement authorities. Yeah, sorry.
There was another question at the back. If you could raise your hand again. Oh, over there in the middle.
Yeah, I'll just do it like this, so without much for the sake of time. So I just have 2 questions very shortly. So I'm Professor IT Law Enforcement Liability and AI, so it's my background. I have a question for you. When do you consider that an AI system is safe? Because the title is confusing. When is an AI system safe and not safe? And don't go to the legitimate safety stage like for free. And then secondly, do we not need to look more at the role of insurances to cover all of these harms, right? Because in the end, as we see, the example of autonomous vehicles is often used, but it's all covered by insurances. So should we worry about liability at all and not focus more on insurances, especially if we consider that AI will become safer in the future, which is according to the prediction, right? So less accidents will happen. So why don't we establish just a fund to cover all of these spare incidents of AI? So these are 2 questions. If you have time to answer, otherwise I will catch up with you during coffee. Thank you.
Insurances.
Also, maybe you take the independent.
Thomas.
Back to remedies.
maybe to come quickly back on the independence question. Yes, but you see, that's where it starts. Data protection supervisory authorities have to be completely independent, clear. Market surveillance authorities, not so independent. We've just heard that it's not the same terminology and certainly not the same expectation. And your authorities, as you said, I don't think that's a problem because we will have to see how it all works. The main thing is the moment you can say, we have a job to do and we need certain information, you have to get those information.
You could have one source of redress in this way,
no? No. But happy to discuss, yeah. I see multiple ways of redress, but okay, to be discussed.
Yeah, of course. There's a little bit of a problem when it comes to biometric data, because there's people saying that biometric data is not special categories of data because it's useful, the drill. But for me, and I'm really lucky that we have in the team we have people working on the AI Act and so we can see the interconnection. So everything. This is what I was mentioning in Article 22 when the AI Act is not going to be open for us, but then we can go back to Article 22, and again, I think this is an amazing resource because it's also about the right to explanation, right? And I think also the court has been quite good when it comes to the right of explanation and try. It could be better. It could ask the provider to provide the source code, but I think we're never going to get it. So yeah, I think definitely. I think the moment we saw biometric and the way biometric information was being, defined and portrayed in the AI Act, we all instantly thought that this was more of a GDPR. But then we also know that when the AI Act was being adopted, DG just had very, very little to say, and this is why we now have discussions that are about the lack of compatibility between AI Act and GDPR, which again I don't subscribe. I think this is just constructed consent, manufacturing of complexity by industry in order to force us to either reopen GDPR, reopen AI Act, or reopen the two. And for example, this is something that we haven't mentioned, right? Even the impact assessments, right? We have data protection impact assessments and years of experience of impact assessments, and then we have, which already contained a part about fundamental rights, and then we have FRIAs, and then we have companies saying, oh no, but it's a redundancy, we have the same, and who has been in charge of that? Oh, it should be market surveillance authorities, not DPA. So yeah, I think we have to be aware of the potentialities of these overlaps in order to be as strategic as possible. But yeah, for me, I'm more scared about the other part because I really think this is going to have something we have to fight against. And even we can hear that from within the institution. So yeah, let's be careful. But thanks so much.
I think we're running out of time, but does anyone want to attempt the 2 final questions?
I mean, I'm very bad with insurances.
Yeah. Okay, I think we'll close it there, but feel free to come up to the speakers. And please join me in a round of applause to our panel. They were fantastic.